I'm telling you, when it rains, it pours on you with your dog, him with his dad.
It's non-stop.
Non-stop.
My whole soldado.
Are you okay, Hilda? Did he push you really hard? Did he?
You got hit on the right side.
But is he okay?
He's been running around since.
Like nothing?
Nothing happened. Thump, I heard. Everybody saw. Workers stopped.
How were you?
I was freaking out.
That's all you need, something to happen to the baby.
That's all I needed.
Did he fall? Did he stumble or he kept running?
No, he kept running. Still running. Didn't take me one bit. What are you doing?
That's what's more important. Okay.
So guess what happened yesterday, Professor? You know how they're always nailing us on that we have to leave at 9? You know how they're always telling us? Well, yesterday they came in and they said, are you guys ready now? And it was like 8 o'clock. Like, you guys are the last ones here.
Who came in?
Both Irene and Kelly.
Irene and Kelly came in and said, are you guys ready to go?
Yeah, because we're waiting. You guys are the last. And then
They wanted to go.
Yep. And then they said, because you guys are always the last class. And I'm like, we just follow directions.
Oh, well,
I thought that was
it's the
pretty
last week.
That was pretty funny though.
Just checking for ahead of the curve here.
I'm sorry, I wasn't clear. The answer is, we are obligated to provide X number of hours of instruction. And if we don't, we're in violation of some rules.
Yeah, that makes sense. I figured something like that. I think what we do is we make up for all the lost hours of other classes.
Or Saturdays.
Can you get that joke?
We just love testing air conditioning.
You like Esther?
All right.
That's what I
No,
like.
you're fine.
So Mac, there's very little you can do wrong.
Thank you.
You're very welcome.
Okay. I didn't have a chance to send out anything for tonight because I was working on your final exam. And it is complete.
It is.
It's the
We can talk about
multi-state
that.
and the essay. So what we're going to do quickly, I think we're going to spend any time on cases. We're going to go through the entire book and look at the points and rules that are taught. We're going to start with chapter 1. Would be on my part, don't you think? Look at the summary of content. I think chapter 1 is useless.
It just talks about the history, right?
Let's go to chapter 2. Section 1 talks about the significance of characterization. Tell me, sir, in what different ways can you characterize property? Why does it matter if we characterize it? And I guess the third question is the same as the second, and that is, what do you do with that kind of property at the time of a divorce? What are the different types of
So in terms of characterization, you're referencing community property, quasi-community property, separate property?
I am.
Okay.
Just answer that question fully.
Okay, so
What difference does it
it's
make?
important so the court can properly allocate the property at the time of dissolution.
Forget about the court.
Okay.
It's important so that you know what the court is likely to do so you can settle your case.
And that was going to be my next answer. In the event you choose to do your own settlement, it's important that you know the designation of the property so you can settle your own case.
That's right. When you are thinking about making a settlement demand, or you are responding to one, you need to think about, A, what would the court do if this case goes to trial? B, what areas might your client make concessions on anyway?
All right.
Two women have been fighting probably for about 5 years over custody, visitation, timeshare, over their daughter. I filed what was probably the third or fourth request on behalf of one of the mothers, because the child has two. I filed a request, which is really the third or fourth, for joint legal and joint physical and a 50-50 timeshare. And it was agreed that they would go to a 730 evaluator who did an extensive investigation. And a whole lot of her recommendations were satisfactory to both sides, but there were probably a dozen smaller issues in which the parties were in dispute. Sheila sent me a proposal yesterday. I responded and said that's completely unacceptable. I sent back to her a checklist of what we would live with. Her associate wrote back and said, that'll never work. Sheila said she'll see you in court in the morning, meaning today.
Ex parte?
After that,
No.
Sheila writes to me and says, come to court early. We're going to talk. And the four of us started talking at about 8:10, and an hour later, we had every point resolved. Case is settled.
But that could have been done day before on the phone or back and forth, email. No.
I guess I have two comments about that. First, many cases settle on the proverbial courthouse steps. Second, I'll tell you what I told my client this morning, because Sheila was very capable and very bright, and that she could be very harsh in how she approaches things. Don't be bullied, and don't enter into any agreements that you might regret later. So as far as I'm concerned, if we reach an agreement, we might just say, write it up and we'll get back to you, which is in fact where we left off, but we really do have an agreement. Sheila was just fine. Just fine. At 4:30, I got a phone call from another lawyer who's in trial with her, Wes, who said she is the most aberrant liar he's ever met in his life.
Who?
That's funny.
Arnold said about Sheila.
Sheila?
Whole face to the court. Horrible. Horrible.
Are you serious?
Quiet. Quiet. I think except for the PR implications, he contacted the bar. Whether he's right or wrong, I don't know.
He will?
I don't know.
What was the first?
I would guess he won't. It creates
More problem than,
difficulties down the road.
yeah.
What's the first case?
Sign in, please. Who used to say, please come in and sign in, please? Who used to say that?
You used to say that.
The moderator on What's My Line.
Oh, God.
Now, who was that?
Who was that? What's my line?
One more of these to sign and we're done.
What was the first set of cases we did? I'm trying to remember.
Case of bid,
Case of bid, thank you.
that starts the first one.
Thank you.
Is bid in this class? All right, so, if people own things before marriage, and then they get married, on those facts alone, does the character of the property change?
If they,
Depends on the
No.
property.
well, if they have, they had the property prior to the marriage, separate property.
Now they're married.
Prior property is still separate property.
Now they take money that they had before marriage and deposit it into a joint account.
Well, then it depends, as Aaron said, because intent maybe that becomes a gift to the community and it's community property,
I did some of this.
which could be erased ultimately if one of them makes an issue later on.
Under what rule?
That it's a separate property.
Under 2640, it seems to come up a lot. If they can trace what they put into joint names, they get it back. And at what interest rate?
10%. 10%, period.
Zero.
Oh, 0%.
No interest, yeah, no interest.
Zero.
No interest in 2640. I know it's tricky. It's tricky.
That's why I brought it up. They get it back. Period. End of discussion.
So we assume that's gotta be in one of the multiple choice questions.
Hold on. Answer that again. They have to trace it though, right?
You have to
They
trace
have
it.
to trace
They trace it, they get the money back, but no interest. Because he asked if there was an interest, I said 10%, I don't know, 10% from something or something.
No, that's, we used
You gave
to.
us another example early on. I've always struggled with this. If I put it, you said a joint bank, you said a joint checking account?
Separate account, separate money, separate property. After you get married, you put part of that, all of that into a joint account. At that point, it becomes community, depending
Yes.
on the intent of the people, that it's a gift to the community. But
Correct.
You can trace it if you start falling, you start having problems, you went out, dissolution, divorce, what have you, separation, then if you can trace it, then you can collect only the initial investment, initial money, correct? No interest.
So husband puts his $10,000 into a joint tenancy account, and she says, you'll always think that that's your money. And he says, no, I put it into a joint account because I consider it to be our money. And then, when they're in the middle of a divorce, he says, I've got the deposit slip. I can show you where that $10,000 came from, and I want it back. And she says, no, you told me that it was now our money, and you don't get it back. Excuse me, miss. What's the ruling on that?
Well, it must have been an oral agreement.
Louder.
An oral agreement, it's not always enforceable. However, if you rely on the Marvin action, then it could be.
As a general proposition, the thing to remember is his right to reimbursement exists until and unless he makes a written waiver.
That's the presumption. That's the 2640 presumption, right?
The presumption is that,
2640,
the
you
Marvin
make a
action
separate
come
property
about?
contribution to the
Explain the
community.
Marvin action.
You get the principal back sans interest upon dissolution of
the
marriage,
presumption
unless
to
you
get
have,
back.
unless you have
Unless
signed
you have
written
it.
waiver.
So when he says,
That's the.
don't worry, darling, I put that into our names because it is to be our money. But later he says, I want that money back. And she says,
No.
you told me that it was our money.
Not enough.
And his lawyer says,
Not enough.
objection, irrelevant, an oral representation that it is now joint money isn't proof of anything.
Right.
Objection sustained. I'm not even going to listen to what you say he said.
And that's true for any kind of account, not just a checking account or a savings account. That's true for an investment fund of any kind, right?
Mhm.
That rule applies across the board.
Across the board. Okay.
Transmute.
Husband buys a house for cash
Right.
with all his money. He puts it into joint tenancy. Wife thinks it's their house. They get a
There's a
divorce.
title there.
See, I always get screwed.
Joint tenancy.
It's
There's
the,
a title, both the names on it, regardless
you
of.
can trace back the deposit.
By putting it into joint tenancy, he's created community property.
All right.
Now they get a divorce. The court orders the house sold. Husband says, I want to be reimbursed for the money I paid to get into the house. Answer, yes.
See, that's where I was excited
gets
with 2640.
He gets it,
I always lose the property.
He gets the money without interest. Is that right?
Correct, that's correct.
What is it that confuses
Well, I
you?
just, for some reason, when I read 2640 the first time, it sounded like they were talking only real property. And so ever since that second day of class, I've just had that.
I think it sounds
buried
that
in
way,
my mind.
but
But you gotta
it
think-
applies across the board.
Yeah,
You get the title.
because my own
Now,
money is
title-
property, exactly.
Julie,
Title
Yes.
money is property.
I perhaps have said this before, but I mean, do you know or remember who Lee Marvin was?
Yes, it was a divorce case. One of the
Marvin
first
was-
cases.
Who was he in the
Marvin
real
actually
world?
The actor, right? You're talking about the actor Marvin?
Certainly.
The Marvin.
Lee Marvin.
action.
Lee Marvin.
Did you ever see one of his movies?
No.
I have. I grew up with him.
Believe no.
In the old country.
Hilda has.
Okay,
She found
So,
out
He was a
Lee Marvin.
American looking guy. He was we thought Americans looked like.
Lee Marvin
Now you realize.
cohabits with a
No.
woman by the name of Michelle Triola.
Mhm.
She later takes his name. I don't know if she ever filed anything in the court
She
to
was
make that happen,
borderline. She just.
but she goes by the name Michelle Triola Marvin.
Michelle Triola Marvin.
He says the relationship is over, and she files suit for half of what was accumulated while they were married,
Mhm.
as if they were married and it was community property to be divided.
Mhm. Absolutely.
It
Well,
was the first alimony suit.
that was the creation of palimony and the Marvin theory the case is really procedurally a mess. I can't tell you what the trial court did, but it did something. And then the Court of Appeal did something. And then the Supreme Court granted review, and it went to the Supreme Court. The rule that comes out of the case, if you can prove, and orally is sufficient in the Marvin case, by the way, if you can prove an oral agreement that whatever is accumulated during the relationship will be shared equally when the relationship ends, the court will enforce it.
On what
That's the
grounds?
rule that came about.
On what grounds? As a contract?
Yes.
Oral contract.
Yeah, it really is.
So that performed on her part, fully performed, executed on her part, by being available, minus not just the sexual, pure sexual relation.
I don't even understand why they talk about it. Unless the relationship was created solely for meretricious sexual relations.
Consideration.
How does that ever come up? Anyway,
But after so
That
many years,
sounds
it's
like
more than
proper
just sexual
consideration.
liaison, right? They
well,
need
after
to
a
get-
number of years, that part of it goes away entirely. In any event,
True.
the court in Marvin said, if you can prove that there was an oral agreement to share equally what's accumulated during the relationship, the court will enforce it. But, Michelle, we find you haven't carried your burden of proof to show that there was an agreement. So, we're not dividing
Anything.
the accumulated stuff at all. So then you would think she gets nothing. But the court said, Lee is ordered to pay you $100,000, nice round number, $100,000 so that you can get settled. Okay,
Wow.
that was just generosity or not being totally brutal.
But the general rule for
So
being
an
an
implied contract.
individual for however many, however long, if you're not married, because we're not a common law state, it's a contract agreement unless she's a putative spouse, or she can prove that there's some arrangement where she was supposed to be paid for the time, or get some portion of the assets or something of that nature, right?
Right.
Because the Marvin was just oh, here's your money.
I gotta tell you, there aren't many Marvin cases. I've certainly had numerous discussions with women about it. I've never filed one. I've never opposed one. Sheila,
I think Wes has. 'cause he's talked about it.
speaking out of school, Sheila was sued by a long-term partner of hers on a Marvin theory.
She lost, I think.
She told us, she shared
She
that
told
with
us,
us
yeah.
our first
And
year.
I think at the end of the day, she ended up dismissing it.
Right.
I don't think that
Sheila
went
won.
to trial.
Yeah, Sheila won.
She did.
Yeah.
She did.
So if the plaintiff cannot prove by clear and convincing evidence, I
I
assume.
think it's preponderance.
By preponderance of
I
evidence.
don't think there's a clear and convincing
So by
obligation.
preponderance of evidence that there was a verbal contract, well, that's not easy to do. How can somebody, 20 years ago, he said
You
this,
gotta prove it up. Bottom line is you gotta prove it up.
so how do
If
we,
she says we had the agreement and he says no, we didn't,
so,
you're gonna have to look for something outside of that he said, she said,
right,
to make a decision.
so,
And by the way, I never had one of those cases in front of me.
so what would be tangible enough?
We'd have to speculate.
A card. I'm so glad you agreed to have this relationship with me. And
I'll always take care of
I'll
you.
always take care of you.
A statement by a
Yes, followed
third-party
by-
witness, Lee told me
Right.
he had made that commitment to Michelle. A
That's your best-
third-party witness corroborated
That's your best time.
Michelle's
Ask
position.
a banker comes in, this was, it's in his name, but he told me he was setting it up for her.
Not sure that would be enough. Setting it up for her because they have an agreement that they're going to share everything would probably be required. You could see a Marvin question,
So it's
and I
tough
tell
to-
you, the rule is,
It's tough. That's tough.
if you can prove that there was an oral agreement to share equally what was accumulated during the relationship, at the end of the relationship,
Right.
the court will enforce
So
it. That's the rule.
when we're powering through these CP exams in the bar, how many Marvin cases have you seen on a community property?
A couple, not, it doesn't come up
See, I
very
can
much.
see now that they've,
But it is like a,
it's
like,
there. It's one of
yeah.
those issues, yeah. I can see them throwing that at us because of the change in the bar. From 3-day to 2-day now, they want to throw as many things at us to see what we can catch.
mhm, mhm.
You know, for point value?
Yep.
You think it's more likely that a Marvin question would come up?
I think so. The essays look much more scattershot. They challenge you to find as many issues as you can and then put them in the appropriate order that they're going to rank you by point value. So you see them low, like the last couple we've seen are just loaded, but it's where do you start? Everything from the remedies ones to the business.
Several class holders.
Yeah, so I can see it happen. Neck with a will. You know.
You can transmute from separate to separate, from separate to community,
Mhm.
from community to separate. I think you can go every which direction.
Okay.
It's going to be iffy if there isn't documentation.
Okay.
I think with the exception of the Marvin case, oral agreements aren't worth much.
With the exception of the Marvin case. Gotcha.
So if somebody says this has been transmuted, they better be able to show you a document.
With an exception of an intraspousal gift.
Uh,
That's not subject to transmutation unless
That's-
it's substantial. If it's a substantial gift,
Yeah.
then it's,
It could still remain community
unless
and
it's
not be
accompanied by,
considered a gift.
unless it's combined with a writing or is proved with by a writing. Like, here's a diamond ring, I give it to you for your 5th year anniversary, it's your separate property. Does it have to have that clear language?
No. And I do think that something like jewelry, something that personal, is always going to be viewed as a gift unless it has extraordinary value.
mhm.
I think the
Like we talked
dividing
about.
line is at $40,000. Once it becomes $40,000 ring, then.
For
we
the
know it's an
purposes of the
investment.
exam, I'm gonna keep that in mind. The value is $40,000, then
That's the,
It needs to be
that's the
accompanied
guiding,
by a writing.
the guideline. And there's a statutory community property presumption
Mhm.
for money deposited in an account of any married person. I'm not sure I'm really on top of that properly. So if I
Right.
inherit some money and I'm married and I deposit the money, that statute would say I've created a presumption that it's community, but I guess it could be rebutted by showing that it was inherited.
Correct, unless you prevent commingling of accounts at the front end.
Now, as a general proposition, an asset acquired during marriage is community property. What are the exceptions?
Gifts, inheritance,
Issue from a separate property.
gifts,
Rents,
inheritance,
issues,
issues,
profits, often separate property,
Mhm.
wills,
inheritance.
inheritance.
What are the rules regarding personal injury awards? Who gets a personal injury award?
The injured party.
It follows the injured party.
If it's a divorce versus death is a different.
I'm talking about divorce.
If it's a divorce, then it goes with the injured party unless there is such a serious imminent need for the other party to be compensated somewhat if fairness and justice requires because she's so broke or he's so broke. And no more.
What if there's a settlement that does break stuff down? We're going to pay you $1 million. $100,000 of it is money you would have earned during the marriage, but for the accident. And $250,000 is for your medical expenses. and $650,000 is for your pain and suffering. Would your answer be different?
Yes,
What would your answer be then?
the 100,000 with the community property, half of it goes to the other one. But the medical expenses is his and the pain and suffering is his.
Let me give you a practice pointer, as all of our lecturers seem to say. If you get money that reimburses you for medical expenses that have been paid for by a health insurance carrier, you have to give that back to them.
Right, that's right. What if the community had paid some of that or all of that, then you have to.
Then the community is entitled for reimbursement.
I think that's exactly correct.
Right.
And who is this girl behind me? Do you know? Yes, I think
Andrea?
I got a phone call today. She's on the other side of the case.
Oh, no.
I haven't met the person yet. But I asked who's on the other side of the case, and that was the name.
It's a small community here.
I dare say. Anyway, unless you can identify part of the settlement or jury verdict as being for lost wages, really it could very well be easier if you had a trial and a jury, because you can and do generally submit questions to the jury. Was the defendant at fault? Was the plaintiff harmed? How much total money do you think the plaintiff should receive? How much of it is for pain and suffering? How much of it is for lost wages? How much of it is for reimbursement of medical expenses? And you have those special questions. I don't know if it's always, but I'll bet it is. If the case goes to a jury, you want them to answer those questions. And you used to prepare special verdict forms. It isn't, we rule in favor of plaintiff for $300,000. The answer could be many pages of questions. Also helps if you want to file an appeal.
So in an essay of some sort, if there's those kinds of facts, then we go by the facts, if this, then that.
Yes.
In terms of,
Yes.
in terms of a settlement for PI. But if they said this was this much goes to this, that much goes to that, and then you.
It may not all go to the injured party.
Injured party, okay.
If you settle a case, unless you go back and look at lawyers' notes, you really don't know. I mean, all that happens is the injured party gets a check and the wrongdoer's insurance company's counsel gets a release and a dismissal of a lawsuit if it's been filed.
And if it's the wrongdoer is the spouse, under no circumstance he gets anything.
I think that's correct.
Is that right? Yeah.
I think that's correct.
Yeah, no circumstance. Wrongdoer.
When you become a lawyer and you're in a courtroom or you're teaching, I ask you, with love and affection, speak up. Don't put your hand in front of your mouth. And don't think that it's a confidential communication. Good morning, Your Honor. Got it?
Got it.
No mumbling.
I've got a case today in which it's not even clear if my client, the woman, wants a divorce or a legal separation. In fact, what I did today was prepare something I've never prepared before. She has said that he contributed a lot of money toward the acquisition of their home. I said, can you prove it? She goes, absolutely not. But I know he did. And when I sell my house, he is to get that sum of money back. And I don't care if you can prove it or not, it's the right thing to do. I said, it's nice to meet you.
What else can you say at that point?
Fuck him. If he can't prove it, he doesn't get it. You could say that.
You continue.
A lot of lawyers in town would say that.
Give him a nice letter, wouldn't you? You sure you got one of those letters? You don't want two of them. One's,
It's funny.
second one's not even as funny.
You know, this isn't very helpful for the bar exam, but I do tell you, after you learn all these rules, and then you try to learn the facts of your case, and figure out what a judge might do with it, and figure out how a settlement should be structured, because this is likely what the court will do. I do ask you to sit back a little and ask yourself, is this fair under all of the circumstances? And if the answer is no, you don't necessarily have a fiduciary obligation to your client to say you're entitled to all of this money. Don't give him a penny. Don't give her a penny. You still can. It's important that you make sure the client knows they may indeed not have to, but in terms of getting the case settled and, God help me, being a human being about it, you can be accommodating. Don't give away the farm, but you can be accommodating. Let's talk about premarital agreements for a minute.
God help us all.
Prior to the 80s, I think the rule of law was a case which was recited forever that made waivers of spousal support unenforceable. Do you all know the case that I'm talking about?
Is that
No.
The case is Dowley, D-A-W-L-E-Y. There was a prenup. It had a waiver of spousal support. The wife wanted the prenup not enforced as to that provision, and she won. And the answer was a waiver of spousal support is unenforceable. It is against public policy.
Per se.
Per se. Now, the Uniform Writers of Legislation come along, and they write the Uniform Premarital Agreement Act. And interestingly enough, if you look at that section of the Family Code, it doesn't say anything about waivers of spousal support are valid or may be valid. The words spousal support aren't in the Uniform Premarital Agreement Act as adopted in California. It just says the parties may agree upon anything.
So if the parties agreed, then it's enforceable.
Correct.
If parties didn't agree, it's not per se enforceable.
If there's no agreement regarding spousal support, the person who is entitled to spousal support, either pendente lite pursuant to the computer program or permanent under the factors set forth in 4320, is entitled to it. If there is not a premarital agreement, or if there is one and it doesn't say anything about spousal support, the party who would be factually entitled to spousal support certainly can get it. Certainly can get it.
As long as they entered the agreement voluntarily and not coerced and not duressed. And it's also even helpful if they get independent counsel to review the entire matter.
It's critical. It's just critical. Do we have that in the back of the book? The Premarital Agreement Act?
The act, I think so.
2 or 3 pages. I think it's like 1600 at sec.
Yeah, it's, let me get it for you really quick. 1,600. Yes, it's actually 1,500 effective premarital agreements on page 810.
Let's look at it together for a minute, folks. There's a lot of premarital agreements floating around. I just dealt with one that's 27 years old. Go to 810, please. 16. Well, it's really 1,600.
1,600, okay.
Starts the Uniform Premarital Agreement Act.
Okay.
And if you look at 1612, well, I'm as wrong as I can be. Uh, 1612 sub C talks about a provision in a premarital agreement regarding spousal support, including but not limited to a waiver, is not enforceable if, and then it talks about, it may not be enforceable if they were not represented by independent counsel at the time of the agreement, or if the provision is unconscionable at the time you seek to have it enforced. And I just dealt with that one in recent months.
If you go back to your contract,
Is that the very bonds amendment?
excuses.
Didn't they change that into very bonds?
Didn't they change that? What?
Didn't they change that in the statute because of bonds? The bonds wasn't, very bonds wasn't.
I don't know the answer to that, but I do tell you, and I will continue to tell you, that the bonds decision was shit. That woman was rushed into a wedding and signed an agreement hours before the wedding, written in a language that wasn't her first language, and was taken to his lawyer. And I gotta tell you, I think that was enforced against her because Barry Bonds was who Barry Bonds was. And he was, that was in a San Francisco court, and Barry Bonds was a San Francisco hero, absolute hero.
And they got away with it, huh? Wow.
If you take a judicious look at the facts of bonds, that agreement is not enforceable.
So she could not come back and do anything about it.
Well, I think that's why they changed it. I think that's why they changed the statement like that, because it was so unconscionable what the court did in that case. That they
Tell you about our local courts. Be careful about filing ex parte applications for emergency relief. And boy, did I get hammered, along with my opposing counsel get hammered, recently by Dale Wells, a close friend, served on the bench with him. The other side filed a ton of exhibits. We responded with a ton of exhibits to deflect what they were saying with theirs. And Dale, when we checked in with the courtroom assistant, she said, the judge wants to see you guys before the calendar is called. And we go back into chambers and he hands us a case that says, judges are not pigs whose responsibilities are to rummage around through the shit to find a nut or a morsel of food. And you better not throw that much at them. I'm not reciting it completely accurately, but I tell you, that's what it said. It did say judges are not pigs.
So what was his concern, that there were too many?
Much too many. I think he said that he had spent 2.5 hours preparing the case for the next day. He's got 30 cases.
They got into his Bible study time. Judge Wells, right? You piss him off if you get into his Bible study time at night with his wife.
He didn't comment on that.
How do you know that?
Because I work with his wife, she's a teacher.
I know he's a believer, but he's not.
Mrs. Wells is a teacher. What's her first name?
You know what, I just know her by Mrs. Wells. I can't remember.
I think it's Mary.
Oh, yes, Mary, yes, Mary.
Pastor before he became a lawyer in the church. He's actually a pastor. He's a
No, he used to be a pastor before he became.
He was still a pastor until a couple months
Still a
ago.
pastor, yeah.
He preached every Sunday morning.
Where?
Washington and Fred Waring.
Oh, the southwest.
Northeast corner, I think.
Southwest
Southwest?
Church, yeah. That's the only church over there.
Yeah, it is.
I don't think that's correct. I think it was a
Guess where they
tiny
met?
little church.
Him and the wife met on Match.com.
Who?
Judge Wells and Mary met on Match.com.
So it's a more recent wife.
They've been married for
They've been
15
married
years.
for a while, but they met on Match.com.
Wow.
I didn't know that.
That
I know the old.
I'm sorry.
Online, they met online.
That I'm surprised.
That
She was
also
from
is
out of state.
that also is a growing reality in our society.
True.
I'll tell you what else is a growing reality in our society is divorces triggered by spouses discovering that their spouse is looking for someone
Online.
on that site, online.
Who was telling us that about Facebook and old flings? Come on, Judge Hawk. Judge Hawk.
Oh, yeah.
What did he say? People are meeting old flames on Facebook?
He gave us some statistic that was just, I found shocking. The person
Because
goes
he
on
has a Facebook.
Facebook. I found him on Facebook. Because the person goes on Facebook and they find an old fling and they reconnect with that old fling
Hope you don't.
in a friendly way.
And then he-
They're hooking up with that old fling with he said 2 months. In less than 2 months, and the marriage is in trouble.
I thought they were going to
Don't
say
people realize?
pornography. They see pornography.
Don't they people must forget why they are old flings. They old.
I'm so afraid of meeting someone online. I'm not that desperate.
This is a
I
credit card.
I'd rather go down underneath the bridge.
I wouldn't.
What? That's cash. I just said, unless there's a credit card involved, that's cash. Online is credit card.
I would never do that.
I don't.
Might as well. You don't know where they're coming from if you're meeting online. They could be
The
someone
lies that
underneath
they
the bridge.
I think,
God help us
I don't know.
Opinions.
I mean, I've been told that most men representing that they're single, looking for someone to date, aren't single,
Necessarily, or who they are.
or aren't even who they are.
And then they
all.
can.
I've always told,
And then this is some of the.
most women representing women are actually men.
That can be true.
That could be true. That could be true.
Also, men
On
have
it.
3 or 4 on the line. Somebody may be coming from Chicago, but there are 3 or 4 in Palm Springs area. He's telling everybody he's coming for them, and then he gets here and says, sorry, you're not one of them. You're not the one that chose.
What are you talking
Do
about?
you know how often this happens?
No idea.
Oh, then I come in my office crying at the guy that
But
they
you-
were expecting.
What are you talking about?
I mean, you just don't know who's on the other side of the
What do
street.
they call
It
that?
could be
They
someone.
start building an association.
How do you ever really know who you're about to go out with unless you've known them and been around them
Exactly.
for a long time?
You
That's
don't
the
know.
point.
Exactly.
Even the ones
That's really
you
not
do know.
You may not know.
You may not know. I mean, even the ones you do know, you may not know.
Well, you know, Bill Cosby was Mr.
The one that I choose.
Family Man.
Other shop.
Mr. Family Man,
Yeah,
guilty on all counts today at 80 years of age.
And did you see
it's
the,
about time.
That's horrible,
Did you-
but it's about time. It is about
Did you
time.
see-
Nobody's gonna tell me nobody knew this was going on for all these years.
I told my wife tonight at dinner that if one girl made accusations, it could be a shakedown.
Right.
If it doesn't do it,
Doesn't.
I think they're all telling the
it was
truth.
something like
actually.
20, it was something like 20-something, and they're
And
identical.
they're all
And
saying the
he
same
admitted-
story.
He
He
admitted,
admitted.
he admitted
I
in
think what
civil,
makes it,
in the
Yes.
civil case.
Then he
with
gives
this
them
gal,
medicine, or
and
gives
he
them-
I
gave
think
them
that's
Benadryl to loosen them.
that's what
And that hung him.
That's right there.
inducing them with
Right.
with
And these are
medication.
young.
By the way, do you want that muscle watcher?
Yes,
You look all straight.
I'll take it voluntarily.
You want that foot rub?
A back row.
Yeah, it's about time we get to jail.
Oh.
It's getting hot in here.
It's very hot in here.
Baltimore just gave,
I'm always
Buffalo
outside.
their 16th pick.
I'm looking at the chapter summary for chapter 1 real quickly.
That was
So
worthless.
what? Oh my
Remember we said
gosh.
that chapter was worthless.
Well, I'm just looking at the summary to see if there's anything that's worthwhile.
What was in that one? That wasn't,
Chapter 2 has more meat in it.
yeah, chapter 2 has a lot, that has the.
That has everything. Well, everything that we need. The
Let's go to the
foundation.
chapter summary of chapter 2. It's on page 155. Community property, any property acquired during marriage by the effort of one or both spouses while living in the state. That's what raises the potential issue of quasi-community property. Date of acquisition is important. Evidentiary presumptions exist. The labor belongs to the community. I think on page 156, it's important. If there is a presumption, and there's many out there, and you're challenging it or claiming that it shouldn't apply, it's your burden of proof to prove that. Dale used to, but doesn't. He gives this, I guess, vaguely useful speech now before he starts court. But he used to talk about a balancing thing. And when you come into court and you're making a request, it's balanced just like that, absolutely equal. And if after everybody has had their turn, the pendulum favors the person making the request, they win. If it disfavors the person making the request, they lose. If the evidence is evenly balanced, the person who's making the request and has the burden of proof loses.
Right.
Case
Time
dismissed.
goes to the runner.
He uses that analogy all the time. I've been in front of court with him, and he's brought up something like that.
He doesn't do it anymore.
He only hands you articles. Since judges are not allowed to. He's not happy. He was not happy. He was not happy.
Who was not? Dale was not?
Yeah.
When?
When he handed you that article.
Oh. He did not.
You gotta think about how much time did he spend looking at that article?
No, he's got it handy.
Oh, does he have it handy?
A couple of years ago, he put it on a ledge in front of the jury box for everybody to pick it up. Now he calls you into the woodshed and hands you a new copy of it, and you have made him root around.
I mean, who has time to read all of that?
Well, he's not.
When he has to sit, every day with the full calendar.
Well, the answer is he doesn't. I've been there. When you got a trial schedule, it sells. When you have a
Right,
trial
right.
schedule, they come in and say, we want this postponed. There's a good reason you postpone it. Now you got the whole afternoon.
Yeah.
The problem arose for some of our judges when those things happened and they left. They just went home. They just played tennis. That you can't do. I worked until about 6 every day because at about 4, I started working on the next day's calendar.
Yeah. Yeah.
I think I was always the last person to leave. I've never had any great faith in my academic acumen, and it takes me a little bit longer, I think, than the average person to get stuff. So I spend the extra time needed, that's all. I have in the car and maybe I'll go get it after the break. All of those forms that I told you about.
Oh, great, thank you. Awesome, found sheet.
Which forms?
Forms.
Filing for a divorce, responding to
ones in
the
the back?
petition.
Oh, okay.
Moving around the house with my wife.
Just start filling them out. I'm just trying to see.
She'd sign every goddamn one of them, put them on my desk.
So this guy has about
That's a bad joke.
$50,000 worth of stock at the time he gets married. While he's married, it increases in value to $60,000. Wife says that's an asset that came into existence during marriage. Maybe the 50 is his, but the 10 belongs to the two of us. Is she right or wrong?
No, wrong. That's our separate property. It's a separate property.
Because the growth of separate property is separate property.
Mm-hmm.
I'm looking at the summary of Chapter 3, Section 5, starting at the bottom of 194. I think we've covered it. There are states, and it's interesting, whatever the hell the GANANCIAL rule is, separate property, fruits, and profits are community property under the rule of usufruct.
Oh, the usufruct rule.
Yeah, usufruct.
Just go with usufruct. Just go right.
You know what the usufruct is, right?
We looked at it.
We did look it up, yeah. What does it stand for? Usufruct.
Okay, what do you do with this? Look, and this is back to the personal injury issue. So the wife gets a recovery of $75,000 for her accident.
Okay.
And there's $10,000 in the community property bank account that they use to pay bills. They put their paychecks in there and they pay their monthly bills. But now she puts her money in and there's $80,000. And 5 years goes by and they put in another $500,000 and paid another $500,000 worth of monthly bills over the course of 5 years. And there's $50,000 in that account at the time of divorce. Whose $50,000 is that?
Well, that's when you get into the trace backs, right? You get to start getting the trace backs. You find out how much of the money.
The challenger has a burden to prove.
Yeah.
And if he makes his.
And it goes to the delay. It's her award. You know, did you say 80,000? What her original award was? She popped in the account. You said it was.
Whatever they expended together. I mean, that's that they expended it together.
Right. They expended it together. Depends on what they bought, of course, but.
I think if you look at the 1, 2, 3, 4, 5, 6, 7th bullet point, toward the end of that bullet point on page 195, what I've just described is a personal injury recovery that has been so commingled with ordinary community property that's an exception to the personal injury proceeds going to the injured party. You just really can't know. I mean, there used to be, I think, in other courses, FIFO, first in, first out. Mm-hmm. But this is 5 years later. They've put in all kinds of money. They've spent all kinds of money. She should have just put it in an account in her name.
So then the injured spouse wouldn't be awarded no more than half. It would just be looked at community property.
That's correct.
Yeah,
Because
it's impossible.
It's confusion. When a court gets confused, they're just gonna fall back to community property.
and can do so very properly by saying, if you think it's separate property, you have the burden of proof of persuading the court by a preponderance of evidence that it is separate property, and you didn't. If I don't know the answer, the person who had the burden of proof loses. Chapter 4 summary.
Because there's no way to determine how much of the separate property has already been spent. That's really the hanger. Because the court's gonna look at this, you put 50 in, and over a period of years, through deposits and withdrawals, you have 50 left. Now you're arguing that that's
my
50.
Yeah, you can't do that.
You need to be able to demonstrate, you need to be able to trace it back very clearly, because, and show how much of that original 50 you put in has been expended as on separate property or as separate property. It's almost impossible to do.
Can two guys get married?
Sure. Get
No.
married? No. Modernly. Depending on the jurisdiction.
Previously, could they have registered domestic relations partnerships?
Yes.
Yes.
And if they ended that partnership, what rules apply?
Community property rules.
All of the same rules as apply to a divorce. There was nothing different. And now, I assume, because of the United States Supreme Court decision, I don't know, never asked the question, I assume that nobody files for a registered domestic relations partnership.
No, I don't think so.
It's the same as a marriage,
It is.
so if you're going to create that relationship, you get married.
So in California, that is the case.
Yeah.
Marriage is,
Cross country Supreme Court rule.
right,
Absolutely valid.
Yeah, it's not just the West Coast
across the.
states anymore. It's cross country.
So, husband and wife are married for a long time. They break up. Wife says, I'm going to sue you for divorce. She files the case. She serves him with the case. Nothing more happens. He believes he's divorced. And 2 years later, he gets married to somebody. She's a rock star. While they're married, she earns $25 million. Later, she wants to divorce him, and she discovers that when he married her, he was still married. He says, I didn't know that. I want spousal support and half of what she earned while we were married. Does he have a remedy?
Yes,
He does?
yes,
He has a remedy.
yes,
He's gonna claim he's a putative spouse?
yes.
He's gonna claim he has a putative
Yes.
spouse? No way.
If he didn't know, he in good faith believed he was divorced and married this woman, why not?
You can contest the good faith. He did nothing more than just believe that was done.
What if he really believed?
Well, shit.
Isn't that a good faith
People
belief?
in prison because they have crazy beliefs too, and they really believe those things. So they see them every
It's a
day.
good faith belief that you're divorced and, he's, no?
I would
The
argue.
hypothetical you hear is that they
She,
accumulated something and she is seeking to have it declared
Of course she
a putative
was.
spouse relationship. She isn't the multimillionaire.
right. That's what I was thinking. And you didn't see that.
It's usually the person
Right.
without the defect
That's right.
who sees
Without the
putative
defect
spouse.
and needs the
Right,
resources.
But can the person with the defect?
That's a good question. I would argue no. I would argue the
But
facts.
what if he did not know,
But I
he
would-
really believed it was?
Here's what I would argue. I would argue under the facts as presented by Professor Mack, good faith does not apply because the only step he took was to sign the papers and then there's no reasonable belief, there was no follow-up. He never did a due diligence to determine or ascertain the divorce, the
Is
dissolution.
that so?
That's what I'd argue, no, it's so.
A putative spouse is a person who can prove a reasonable, subjective, good faith belief in the validity of a marriage that is in actuality void or voidable. Upon such proof, the petitioner is declared a putative spouse. At that time, the putative spouse has the statutory right to opt for the default rules of the family code.
Yeah.
And it doesn't say anything about he has the defective problem
No.
or she does.
Silent on that.
See?
Well, no, I agree with you, but I'm saying he would have to certainly show good faith, and I think in this case, the evidence is against him. I think
You
her,
would be arguing
I think she would
from her
have a
side.
stronger argument than he would. But yeah, I agree, he'd argue it.
He would argue it, yeah.
Oh, what do you know? What do you know? If you can prove that there's a putative spouse status to which he's entitled, or usually she's entitled, the property accumulated during that relationship is called quasi-community property. I didn't know that until right now. I thought that was property acquired out of state.
Quasi-marital property.
Very quasi-marital property.
Right.
That's correct. That's correct.
Even if it was acquired in
Right,
another
it's called
state.
quasi-marital, not
As long as they divorce in
quasi-community.
California, right?
Quasi-marital.
Never heard that term before tonight.
Really? Yeah.
No,
You really don't like that term, huh?
it's okay. I've never heard it before.
No, it definitely was in the book.
I was looking at it, that's how I learned it, just now. Well, you ready?
For what?
Putting the formulae on the board as to how Pereira works and how Van Camp works. Do you have to do it for your notes?
Yes, I do.
No, it's easy.
Go do it.
Me?
Yes, if it's
Yes, I
easy.
do.
I have to look at my formulas still. Aquí está la formula.
He's gonna do it without notes.
You gonna do that formula?
Pereira.
I can.
Pereira.
I select.
I have this week to
No, no,
study.
I'll get that one. Okay, for everybody.
I cannot retrieve my letter pad
Oh, those
right
muscle
now.
lashes and
But-
walk.
We're memorizing.
Pereira.
Pereira.
Yeah.
Pereira.
Are you having fun with us?
I went to a wedding Saturday night, and there's some absolutely stupid beer commercial where everybody shouts out the same word, like gooby gooby.
Never heard of that.
Well, it isn't that word, but it's some stupid word that they all yell out in the bar.
I've never heard of it.
And at the reception dinner, everybody was yelling out that word. The craziest thing I ever heard in my life.
At the wedding?
At the wedding dinner.
That's crazy.
You guys probably never even see any television. There's a beer commercial
No kidding.
in which they
Let me
yell
look
out
it
a
up.
stupid word.
I'll look up the beer commercial right now.
How?
On YouTube. Everything's on YouTube.
But what are you going to plug in?
Beer commercial that everybody same word.
The stupid word.
The stupid word.
I'm gonna put this, change the way. So Pereira equals separate property plus, pardon me, the interest, which is 10%,
Not really.
times number of years at the community. That's equals ESP. CP is SP reduced or subtracted from the overall value at the dissolution of marriage. And that's your CP. So the separate property at the time of the marriage plus the interest rate times the number of years. That's your separate property. Your community property becomes a separate property as you just took, reduced from the total value of the business at the time of dissolution, and that becomes the community property. And that's divided half and half.
Say the second portion of that.
Where do you put the value of the business?
So, I use separate property, so.
Okay.
So the
separate property
first line is
at the
really
time.
easy. It's kind of like money you put in the bank
So
and it grew.
let's just go separate property.
Interest times the number of years.
So
So
separate
the
property
value
A,
of the business
separate property at time of business start,
at the time of, yeah.
plus the interest, and the interest is the interest rate times the number of years, okay? That equals your separate property. The community property portion is separate property B, which is the separate property value up there, minus the total value of the business at the time of dissolution.
Okay, you did it backwards, but got it.
Got it?
Because we did it at
Yeah,
the
we
value
did the
of this
other way,
side, the other way, but got it. That makes sense too. You get the same result. I like
And is it the
way
correct
you-
formula?
Yes.
Okay.
Yeah.
You got it?
I have it the other way, yeah.
What other way do you have?
The value of the business at the time of dissolution minus the value of business at the end of the marriage plus the rate of return, 10% times
Yeah.
the years.
Multiply by.
But in order to get that number, the minus number, you gotta actually define what the value of the business, what the value of the property is.
Right. At the time of marriage.
At the time, you have to define what the separate property is gonna be at the time of dissolution.
If the value of the business at the time of the divorce
Mhm.
is less than the total in the first line, there is no community property.
Right.
Do you agree?
Right.
Yeah.
And to put it another way, the value of the business at the time of the divorce has to be larger than the value of the business plus its percentage growth. It has to be larger than that for there to be any community property.
Yeah, I would agree with that. Mhm. And again, the premise of prayer is what?
Skill.
Yeah, labor and skill. Labor and
Do you
skill.
know the name of the beer commercial? I have to
I
look it
don't.
up.
I don't.
Van Camp is a little, I think Van Camp's actually more difficult to understand once you get into it.
I'm just dying of the heat.
Yeah, it's hot. It's been hot in here the last couple of days.
I don't think it really works.
So the Van Camp model,
You got it.
which I think it's the one, if you're the spouse who owns the business and the business has increased in value, you're gonna wanna push the court for a Van Camp model. Because you don't want your spouse getting the community property. The Van Camp model is what's referred to as the salary or a commensurate rate of pay or annual earning. I call it a salary.
Absolutely.
Okay, times the number of years married minus contribution to the community times the number of year marriage.
Exploded the whole way.
And that dollar value
Leave that door open, please.
is CP. That then becomes CP minus the total biz value at time of dissolution.
Do it again. Say it again, please.
That becomes
Start with the econ.
Okay. Van Camp, to determine what is community property and what is separate property in Van Camp, you take the salary paid to the spouse, because the premise of Van Camp is that it's basically the luck of the market. It's the actual implementation of capital or investment of capital in the marketplace. So it's the salary
Of
they're paid to on an annual rate, yeah, times the number of years, minus contribution of that salary to the community.
In what way? In what way?
Well, that's how they determine it. So that they'd be a fact pattern. Mary made $500,000 and Mary paid $350,000 to the community, over the life of the marriage. And so that 150 is community property. The business value is worth 2.8 million at the time of dissolution. So then the 2.8 minus the 150K, and that number is the separate property. That stays separate property. The difference.
It seems like in both formulae, the owner of the business is headed toward having significant separate property.
Except for, yeah, he or she is, but I think the owner of the business under the Pereira model receives a lot less of the return on the investment of the growth of the business than they do at a bank can. If I'm a spouse who's at home with the 3 kids, I'm going to certainly want Pereira. And if I'm the spouse who's been running the business, I'm going to want bank can. Because you make more. You get more of your investment.
Okay. You know how to answer an essay question that has those 2 formulae, the analysis.
I
You
can,
okay with that?
yes.
Skill and labor versus capital investment.
Right.
I think that's what they want to really see if they, and then the formula.
We don't have to compute.
Because I've seen essays, we've seen the model answers where they have it wrong,
Yeah, correct.
but they have the identification of the theory behind the
Yeah.
two,
Right, but they don't have the
but
formula.
they have the formula wrong.
But we don't have to compute, do we?
No, they never have you do math.
So when we had last time, one person computed, the other did not. The person who computed had it wrong, the other one didn't even touch it.
As
Both-
long as you can
both were model
articulate it,
answers.
Articulate
Both
as
were model
long as you
answers.
can articulate it,
the
I think
formula
you're-
behind
they give
it
you points.
and the actual formula, I think, yeah.
And both were on the bar side.
Take a look at page 386, please.
It's John. Both were on the bar side.
Stormy Daniels what? Movie?
Both were on the bar side.
Reservation?
Well, they don't have-
386?
386.
He's in trouble. He's in Fox.
Who?
Don.
Who? Donald.
Donald
Oh,
is
get
in
over
my
yourself.
Fox and
There's nothing gonna happen to
Friends.
Donald.
I missed it.
Oh, he just started,
You went
he
nuts.
said a few
He
things,
said a few stupid things. He needs to stop.
as usual. He's got no filter, all right?
No.
Let him
I
do it.
missed it.
None.
I gotta look it up on YouTube.
Nothing major.
Freaking head explosion.
Does that box help anybody?
Yes, that's how we learned it.
Could you draw that box without looking at that box?
Mm-hmm.
By,
I will by
Yes.
Saturday.
yeah,
I have my flashcards.
yep, definitely.
Chapter 7 summary on page 421. So perhaps if you are the bench officer, if you look at about the 6th bullet point on page 422, you do both a Pereira and a Van Camp analysis of the facts that you're presented with and make a decision. This is where judging comes in. Make a decision as to which formula will
Yeah.
achieve substantial justice better. Both parties have the statutory management and control rights of community property, but in the real world, they rarely do. I'm starting 6. The summary of Chapter 6 is on 524. Interesting, third bullet point. Spouses are partners who are bound by good faith and partnership level fiduciary duties. A spouse does not have the right to destroy community property without the other spouse's consent.
Absolutely.
When would that come up? Honey, I'm going to burn the car.
Think about it.
Okay by me.
How many times you hear about these spouses, they get these fights and the guy breaks the, whatever, breaks the chair or slams the door,
He owns that.
Yeah, it's happens. But that's the whole thing.
They let you do that.
That's fun.
My neighbors were in a domestic violence dispute, so I ran over there because she was calling me. And he was breaking everything in the kitchen, and the cop just, wait, we can't do anything because he owns half, let him break whatever he wants.
Really?
Yeah, and then
That's
he told
bullshit.
her.
That's a 415 under the
Yeah.
penal code.
And then she said, and then you can sue him to replace everything because they let him destroy everything in the
crazy.
kitchen.
No, that's
That's crazy.
a man favorer cop. And a woman
awesome.
disfavorer cop.
That's crazy.
awful.
Mhm.
That's awful.
That is a crime what he's doing.
I watched it, I was there.
I'm not denying
Something
that.
wrong
Yeah,
with
it
that
was
cup.
crazy. So he can just break all the plates, yep, that's
No,
half
he
his
can only
property.
break half the plates. The other half are hers.
That's nuts.
That's
That's
True story.
That's why it's common sense.
That's a palm.
Top of page 525. Equal management and control means that either spouse acting alone has an absolute legal right to disposition. Is that really true?
Yeah.
Can he just sell their $20,000 car for $5,000 because he wants to buy heroin?
No,
No.
He has the absolute right of, legal right of disposition.
So the legal right disposition.
Well, that's true, he does, however,
So,
there are some exceptions.
she wants him to have a car, he wants to dump it for $5,000 and buy heroin. Had a heroin case today.
Really? Let me look at the Max. I remember reading that. Management and control. Each spouse has full power to buy and sell community assets and contract debts without the other spouse's joint or consent subject to these exceptions. Business exception. The spouse who operates a business that is all or substantially all community property has primary control of the business. But managing spouse must give other spouse prior notice, written notice of any sale, lease, or encumbrance.
I've never given my wife written notice of anything other than perhaps I'll be home late tonight, I'm teaching community property.
Well, if you were leasing or encumbering, managing spouse can act all alone in all transactions except.
Just don't put anything on there about how, what are the
Written
rules with
consent of
respect
the
to paying
personal
child
belongings
support,
exception. You need a written consent for the personal belongings, furniture, etc. Cars would be right up there.
They can potentially get into your separate assets, but that's in a
As we
very,
learn.
very, 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 very rare
As
situation.
we've learned from Professor Mack,
What do you want?
we were just talking about what are the rules about expending community property and getting a reimbursement on the expending of that community property on the children of your current spouse from a prior marriage for child support.
Paying child support
Out of community property
on
funds
community property
on
for the
children of
benefit
prior
of a
marriage.
child from a prior
Prior
relationship.
marriage, yeah.
However, the
How do you get
community
that money
property,
back? How do you get that?
I need to write
You
to
need
the
to
judge
know.
who lectures to us every year because 915 and 920 make me crazy. There's a 3-year statute of limitations of making that claim.
That's right, that's what I'm going after, yes. Julie, I want to let you know, I'm going to allow you to spend this money on those kids from your prior marriage. But in the event of a divorce, I'm going to want that money back. So you're
well, I
saying it's
think the
fair.
community property is entitled to reimbursement.
Well, take a look at 920.
Yeah, remember that's the night.
Yeah, Wes explained that.
How do
You
you
gotta
explain
tell
that?
us. You gotta tell me.
Who's Wes?
In the event of
Wes,
divorce.
Your
He's sitting right there. It's not
He's
good. He's
still
got
lost
hair,
him.
he's got hair, his hair's
We lost
going, he's
him.
got his shoes off.
We lost
Feet are on
him.
the table, he's kicking back.
We lost him.
I really liked him. God rest his soul.
I'm taking a 10-minute break and during that break, I'm going to pass out these forms.
All right.
And then we're going to go through the other chapters. Get out of here.
That's not.
10 pounds is what did it.
Yeah, I gotta pick up my daughter at 8. This is so
I need to.
I need to go home.
Cut that.
I need to go into my house.
Did you find a flight for tomorrow?
Yeah.
Oh, good. What time are you leaving?
So you won't be here Saturday? Is
No,
that
I gotta let her know. I'm either gonna fly out at 7 o'clock at
Palm Springs?
Palm Springs or I'll be 10 o'clock at Ontario.
Is your mom freaking out?
It's more, yes,
I bet she is.
yes,
It's
yes.
not easy,
It gets-
trust me.
And she's very difficult to speak to because, I don't know what the fuck is going on. Everything's so, there's just this looming sense of fatality. It's just hard to explain. The last time this happened,
They
challenge
were so
was,
young. You wouldn't be as, you're too
you're
young.
67 years
That's
old, that's
young.
it. 68, 69,
That's young.
it's young,
My parents were 90.
it's young.
The babies don't have daddy. His babies don't have daddy.
It's taken 20 years, 20 fucking years since they were 9.
I think we're going to move the class out into hall.
I'm not kidding.
It's too hot. Professor, at 8, I have to run and pick up my daughter, but I'll come back. And
Again, you
yes.
still have her?
Well, only,
They will be done by then, I'm sure. We only got.
I'm trying to get a ride for her, get Uber and stuff. She's too young to get on an Uber. I don't trust those Ubers.
No way.
She's
No
6.
way.
No
right.
frickin' way.
No way, he's
Not
right.
with young kids.
And she's a very good looking kid, but no way.
The struggles of being a single mom and in law school.
I don't know how you people do it with
2
children.
weeks left. 2 weeks left.
I'm gonna kill him.
Kill. I told you, Mike, don't be quiet.
I'll provide these to you next week. We'll talk about it. I've got one set here.
Oh, okay.
You want me to bring copies for next week? Because I have a limited copy at work.
I think this is one set of what I want to talk about, not 3. This is my whole practice here. This is worth
We
about
could ask
$5
them to
million
give it to
here.
us Saturday. We could ask them to bring it to us Saturday so we have access to them over the weekend.
I'll make copies and tomorrow and bring them all, bring a package, bring
Or
in
we
4
could-
packages.
Yeah, we can make.
Professor Mack, are we looking at a final? I don't remember the last time the final was rather, or the midterm was long, but full of the issues and information we had covered. It was very quick. It was identify, hit the issue, hit the rule, identify, analyze, do the disposition, and move on. Are we looking at the same type of essay?
Yes, even easier, I think,
Oh, really?
because after I looked at all of the bar exam questions,
Mhm.
I learned that instead of giving you a fact situation without instructions, which is what I did, they give specific instructions. Tell us, discuss A, B, C, D, E.
Right.
I've asked, I think, 7 specific questions about the essay.
Wow.
So I'm leading you to the point.
Wow. Okay. So it's not like it was last time where we essentially had 2 to 3 issues each paragraph.
Right.
Because I missed a couple.
That's right.
I missed a couple.
Me too, yeah.
Yeah.
Here's the deal. You get 40 points for coming.
Yeah.
You're gonna get a point for each multiple choice question. That's 25.
So are we gonna go over some of the multiple choice?
That's 65 points.
Shoot.
So you have 35 left to get to 100. And I have 7 questions for you.
Each is worth 5
And
points.
each is worth 5 points.
Gotcha.
Just give me my 60. I'm good.
What?
Just give me my 60 and I'm good.
We have had it.
Oh.
I got in a car accident last week. No car for my daughter. It's just crazy.
Is there safety involved in all these things?
I don't think so.
I'll tell you this, I had a somewhat wearisome, but somewhat good time trying to prepare this. I think you'll enjoy it. And I think you'll all do fine on it.
How about the multis? I truly like multis, but I can see how this could be challenging. I can see how multis and community property could be challenging.
If I'm not mistaken, just go over the bullet points, right, of every chapter.
I think that's a fair approach.
Yeah, I think
That's what we're doing tonight, and that's what you should think about doing.
No our rules.
You're gonna have a practice exam next week.
Go over.
But I think.
Oh, good. We're going to do a practice exam next week. Oh, that's
Let's give you an
great. That's
examination
fantastic.
question next week.
Outstanding. That's great.
And the multiple choice from the bullet points.
Okay.
That's our review.
Well, that's good.
That's fair, right?
So know our
I'm not
rules.
gonna do multiple choice in review.
No, for us
4
at
hours.
home. No, for us at home, to
Okay.
prepare for the multiple choice, review the summaries of each chapter.
I agree.
Okay.
And then I'd like to spend 20 minutes next week talking about the different forms you use for.
So I think
I thought I had,
what
4
we're
sets.
basing is-
okay, what chapter are we on, 6?
Yeah.
Because everybody
I
else
think
is
we
one
covered
of
6. The spouses of right to protect community
Everybody else.
property.
Yeah.
We
We're
covered
on 7?
7.
So we're gonna go to the summary of 7.
Yeah.
The court is ordered to divide community property equally. wife/mother comes in and says, I don't want the house sold now at all. Our kid is 10. She grew up in this house. School is a block away. I work 3 blocks away. I know there's $300,000 of equity to be divided up, but I don't want to do it right now. Can the court defer that sale?
Yes. If it's in the best
the
interest of
child.
the children, yeah. If it's in the best interest of the children,
So,
yes.
so what does husband get when the house is sold?
Yes.
He's entitled to 150 now if it was sold. 5 years from now, it's tanked, and the house is worth 200.
Then he gets half of, whatever after the mortgage paid.
Half of the whole deal. Half the whole value of the asset, because it wouldn't be fair to give him just
Right.
the value accrued during marriage and upon dissolution of marriage, and then let her keep the windfall at the end of the
No,
day.
yeah,
So it's treated as community property,
Right.
50 at that point in time of sale, after kicking it
So if it
out.
goes down, he loses out, even though he could have had his money earlier.
Yeah.
And if it goes up, he gets to share in that growth, even though he didn't pay the expenses of the house along the way. Because we're presuming that when she keeps the house under a deferred sale order, she's gonna pay the bills regarding the house.
But he's still paying alimony, and he's still paying child
He's still
support.
paying all of that.
So therefore, he's still paying
He's
for
still
the
paying
house.
for that.
He should have just stayed married.
Willie Brown. Said it once, I'll say it 1,000 times. Willie Brown.
Willie.
Willie.
That's it!
Willie is the beer.
That's
That's the beer.
That's a beer?
That's it.
That's-
That's
What
the commercial.
commercial is that?
Willie says, I don't know.
But there's no beer called Willie.
That's right. But that's what they say, and it's just stupid and silly. But that's what they say in the
They
commercial.
said that at the wedding? Willie.
No, they say dilly.
That's it.
Dilly.
That's it.
Bud Light.
Bud Light.
Oh,
Dilly.
Now we know it's okay.
You know why
I never
I
heard
know
of
that?
How do you know that?
Because my son says that every time something happens, it's great. He's dilly dilly.
That's what they did after every speech, after the reception dinner.
I have never heard of it.
Instead of applauding, everybody yelled that out. I mean, this is a whole group of 30-year-olds.
Yes, exactly. My son is
Yeah,
11.
it's
Dilly
I found it.
Bud
I found
Light.
the commercial.
You found it?
My son loves these commercials. Get the show it to him.
Dilly.
That's what they did that Saturday night.
I've never heard of it.
It's an old England theme, and the king is at the table, and they're bringing the king gifts, and everybody's bringing the king Bud Light, and he says, "Oh, you're a true friend of the crown, dilly dilly," and the crowd says,
Dilly.
dilly dilly. And then
I'm
what
gonna write that in my exam for an extra
is the
5
last guy comes up and he puts a bottle of wine up there, and the king says, "What is this? It's a mead.
It's a what?
It's a mead that I have made myself, and I quite like it." And the king looks at him and says, "You are going to go with Bob to the pit of misery." And
Is that the commercial?
That's the commercial. And
I've never watched the whole
some guy in the
thing.
crowd, goes, "Pit of misery, dilly dilly!" And he goes, "Dilly dilly." So that's what the kids do.
Yeah.
Dilly dilly.
I've never heard of
But
this.
the kids are like watching beer commercials now.
They're all because they're all.
Well, together, we revealed this for all of us.
Dilly dilly.
Bud Light, Dilly
Dilly
Dilly.
dilly. That's right.
And they did this, I mean, I found it very amusing, frankly. You have to understand, this was the daughter, when she was born, I was not there at birth, but in the days that the mom was in the hospital, I was there. The mother was my paralegal from 1981 up to now. And she does work for us periodically, although she doesn't live in the area. And when I decided to retire from the bench because I had it, I also decided, because she was so valuable to me, that I wanted her back. She was working for a real estate firm as a paralegal. And I called her one day and I said, "Jeannie, I have a question." And she said, "Yes!"
I'll marry you.
She didn't like that job. She knew what I was going to ask. No, I married her on 7/7/7, July 7, 2007. I married her and her guy.
That's awesome.
And
Dilly dilly.
and this,
She knows.
and this was her daughter, and we were at a riding academy. The dinner was in a barn. The marriage ceremony was on dirt. The whole thing was bizarre, but and it went on until 10 o'clock, and we got over at 8:30. I think it went on until 11 o'clock. Anyway, Jeannie worked for me from 81 to 95. In 2004, shortly after they got married, in about 8 or 9, they moved to Temecula. So she works by email. Okay, Section 4, Chapter Summary of Chapter 7. A marriage ends. Sheila used to sing this out. It's going to end by one D or another D.
That's right.
That's not true. It could end by an N or an A, but it's going to end judicially or by death. Do you know how to determine a date of separation?
When they give unequivocal assent that they're never, ever, 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 ever
When
going
one
to get
party
back
says, I
together.
want out. It
By
means it.
expressly, by conduct, by the totality of the circumstance. I'm leaving, I'm moving.
You know, they said that
Dilly dilly.
the purpose of the new statute last year was to try and make it simpler by saying, when you go live in separate homes. But if you read the whole statute, which I think is 70, it isn't as simple as that. And I think it pretty much maintains what the rule has been for a long time, and that is,
791.
what is it?
791, section 70, date of
I'm
separation.
looking at it. Yeah, it's evidenced by both of the following: an expression that were done and conduct, and the court is to take into account all relevant evidence. It isn't just moving into separate places. And prior to 71 or 70, they talked about two factors having to be present. From an objective standpoint, the appearances are it's over, and that could well include living in separate homes. And subjectively, exactly what you just recited, which is one of the parties has made the decision, this is over, period.
Mm-hmm.
We're not going to do anything to try to get back together. And in fact, they asked that question. Historically, you used to have to go testify to get a divorce. Now you can declare the need for a divorce in a form. All you have to do is sign it. But they used to ask the question, and I have to ask it on occasion, is there anything that can be done? Do you think there is anything that could be done in the way of counseling or further trial separation or anything that could help put this marriage back together? And the answer better be no. I told you the story, I think, about the woman who answered the question incorrectly 7 times.
Yes.
Did the two of you suffer irreconcilable differences that have led to an irremediable breakdown of your marital relationship? No. Have things happened so terrible between the two of you that this marriage is just over? No. And on like that. And I finally asked her, why do you want a divorce? And she said, because I haven't seen him in 25 years. I said, I find that is irreconcilable differences. Divorce is granted. I had a meeting today with a young lady who went to these fabulous places that can handle your divorce for a lot less than I can.
$9.99.
Docs by me.
Yep.
Oh, shit.
I thought they closed her down.
No.
She's got something else. She's
I
got
thought they
something
closed her down for
But she's got
practicing
something else.
without a license.
else. She's got something else.
Did they?
Still no.
She is?
And what's the something else?
Forget the name. There's another another thing she opened doing the same thing.
Because I went by her
Under
office and
different
they're
name.
closed down.
On their different-
111.
Really?
They opened up a popsicle shop,
There's another one.
Oh, you're kidding.
ice cream shop
Popsicles?
next door.
An
And
ice
so,
cream?
yeah, I went to the ice cream shop and I saw that she was closed. So
But she has
What kind of ice cream is there?
like one of those, just frozen yogurts and stuff like that.
I want.
You know, you need to go to, you go to, the rolled ice cream spot up there in Palm Springs. You guys ever been to Palm Springs?
Never.
I've been there twice in recent months. I generally 3 times in a
I
year.
never
Really?
go down there. I never go down
Open
there.
up a new, rolled ice cream place down in downtown, outside, by the Dole little spot place. You gotta get, it's pretty good.
The papers done by Docs by me were all correct. They failed to include 25% of what we include. One of the things they never addressed was the status of coverage of health insurance for the wife after the divorce, which is fundamentally not available, but you can put into a marital settlement agreement a provision that says the final entry of termination of marital status will take place on or after, and you put in a date that's down the road. So she didn't do that. And her judgment was final 3 weeks ago. And she comes to me today for me to tell her how to set it aside. I said, ultimately, you're going to spend $4,000. Your chances of losing are almost 100%. And you have a real danger of having sanctions imposed against you because there's no merit to this. You can't just make, and in fact, when I opened up the books a little bit, it said that failure to do something you wanted to do just because you're a pro-per and made a mistake is not a basis for setting aside a judgment.
Yeah, too bad.
So I said, this costs $200, not $4,000, and I've done you a proper service. She was very grateful. She's very sorry. I am giving you next week our marital settlement agreement. It has stood the test of time, and it covers all the issues. A bunch of them will be in there that you will say to yourselves, I never thought we needed to deal with that.
Wow. And I'll let you know how it goes when I leave on the coffee.
What?
I said, and I'll let you know how it goes when I leave on the coffee.
Don't you dare. You put it in your office, practice family law, and come up against me in the courtroom.
I said, it's my wife's season. What's this?
That's a bad joke for Kate.
Oh,
You guys aren't married, are you?
No,
No, not yet.
and never.
She signed
I'm not sure you want to drop a dissolution of marriage petition.
She signed a note that said, what took you so goddamn long? Jesus.
What a horrible thought is that?
Yeah.
So she serves you with the complaint.
Girls come back.
I did phone call.
Oh, that's how you do it.
Sheila.
We're having too much fun, she just
Oh.
keep it.
Barry's in his office and Sheila calls, yeah, I'm representing Bruce.
And then you go in front of Reed's.
No,
No, please.
not now, it's on TV.
What?
No, just do it outside. Just do it outside. Do it outside. Here we go, this is the crazy shit. Do you want to think of your water?
No, I gotta pick up my daughter.
Oh. I'm wrong.
You should what?
Cool. Clint.
You know, he's a Clint.
So if you go in front of Commissioner Reed, he's got a mate.
I proctored her class Tuesday night. She was super. I mean super. I told my wife tonight that I don't know that I do nearly as good a job as she does. Class, well, I think we have a very good class. I shouldn't say that. I think we have a very good class. But I need to do my job and you guys need to be involved. And I do think we accomplished that. The Chapter 7 summary is on 621. Community property comes into existence when you get married. The estate is distinct from the marriage. Okay?
You're in trouble.
I want to go back to this couple. We'll change the facts. There's a couple that gets divorced or go through a divorce process, but it isn't finalized. And when they part, they are still married. Wife remarries, is married for 20 years. She files for a divorce, and the husband files a response for an annulment and claims there is no community property. This marriage was void from day one. She didn't have the legal capacity to get married. Can he get an annulment after 20 years?
Probably not. Not after 20 years.
Sir,
Boy, 20 years is a long time. I would have to agree.
ma'am,
God, I don't know. I mean, it's.
don't know.
I don't know.
He can get an annulment. There is no valid marriage. The timeline is of no consequence.
Wow. I didn't know that.
As of no, okay, then I get it. But then, the property and assets acquired during that time that they were married is quasi-community property.
Is it?
Yes, because if
Has to
both
go back
of
to
them,
the good faith standard, right?
yeah. If you go back and analyze under the good
So
faith.
there's two questions there then. That's the, can you get an annulment?
So the answer is yes.
The
there's no
answer is
time.
yes. Is there community property, quasi-marital property involved? And the answer would be if the putative, there can be administration of good faith belief that they're married, therefore there's a putative spouse.
And because of
I
the
agree with
time,
that.
and because of the time, 20 years. Now, if it was 2 years, then probably not.
That's a good
But 20
question.
I
years,
disagree. I'm telling you. The time period is of no consequence.
yes, for the annulment, I understand. But for the property acquired, while both of them
Why wouldn't
cohabited
you,
as
why wouldn't you
married.
share 2 years worth as readily as 20 years worth? Who would you give it to? All of the husband? All of the wife?
I don't know, I think I would default in analyzing it like a civil matter.
I can hardly hear you, counsel.
I think I would analyze it like I would use the tracing principle. What did you bring into this relationship and what did you bring to this relationship? And make it fair.
I'm assuming in my question that in that 2 years through work, they accumulated some stuff. I'm excluding, without saying it, separate property, which of course would be awarded to the separate property owner at the time they got married or tried to get married. But I'm assuming that there was property acquired during the quote-unquote marriage. And I'm saying that if you're going to apply a quasi-marital property rule, you would apply it to what was acquired during that 2-year period as readily as you would during the 20-year period.
That's fair enough. Fair enough.
That's a good question. Absolutely. That's a thinker.
Question number 9 on the MD,
Question number 9 what?
on the multiple choice.
Maybe. What is the second to the last bullet point? If the parties opt for a litigated settlement. What does that mean? It's either litigated or a settlement. Well, what they're saying is if the parties opt for litigation rather than being able to settle the case. I think that last little point's kind of interesting. If you had a missed asset issue,
We discussed this, Mr. Asher.
Yeah.
We used to use an example. Okay.
if you discover after the judgment is entered that there is an asset that should have been adjudicated that nobody brought up, can you do anything about it?
Yeah.
Yes, absolutely.
Do you open up the case and deal only with that missed asset?
Yes.
Or do you open up the case and take another look at the whole thing?
Only the specific asset.
Only the specific asset, absolutely.
Do we have unanimity on that? Or like an appellate panel? Do we have concurring opinions?
However, if they find that the omitted asset was intentionally in their bad
Right.
faith, then
That's a
there's
big
some
deal.
sanctions.
I think that's a very important point. That may now be an asset that is awarded to the person from whom that asset was concealed. Now, it's not just a mistake. It was an effort to hide or defraud. And that does trigger 1100 and 1101, not just a division of community property.
Like a pension benefit, for example.
Chapter 8, the summary is here's the post-judgment set-aside orders. I found today that I couldn't help this lady. In about 2 weeks, she's going to have no health insurance. Now, is everybody acquainted with COBRA?
Very expensive usually.
Can be expensive, coverage is not as good, but they have to take you. And that's important because God forbid you've got all kinds of health problems. You may have all of the carriers declining to carry you.
Oh, well, they can't do that under Obamacare, right?
Don't ask me about Obamacare. I read it one day. It's 168 pages.
I never read it, and it sucks as far as billion dollars concerned.
Obama doing all of that and then giving all these homeless Obama phones.
Remember that?
They get them still. If you're a Medicare patient, you get
Yeah.
you're entitled to a free Obama phone.
Oh, lovely.
Does he answer your question?
I don't know who answers, but
Hey, this is Barry. Come.
but
You mean robotic?
all these homeless people have smartphones
So,
I go on Craigslist.
and they're on Craigslist and they're Plenty of Fish and then they're on Match.com.
Oh, Jesus.
we're going to chapter 8 now. We're going to go to the summary of that chapter.
710.
Thank you,
There
ma'am.
wasn't much for this other than
Yeah.
county
it's not a lot.
code, the sections to go.
You guys are crazy. I don't imagine. Hey, I went to the bridge over here.
True story. You don't never know.
I have a trial that starts Monday in Joshua Tree.
Oh my.
I'm getting prepared for it this week. We have the client in. When we filed the divorce, she had moved here from England. And she didn't have the requisite residency requirements, 6 months in the state, 3 months in the county. that you had to file a divorce. So we filed an amended petition for legal separation, which requires no residency at all. File that the day you get here. Now, a year later, we failed to change it back. And on Monday, we intend to go to court to ask for a divorce. Our pleading is for legal separation. I think and hope that I can stand in front of the judge and tell him just that and ask him right there to permit us to amend yet again to ask for a dissolution of marriage.
Interesting.
I mean, I went, oh my God, when I saw that.
You shouldn't have no problem if the other party consents to all of that, right?
In general, that sounds like a very sound answer. The court could say, I don't have any jurisdiction over a divorce because there isn't one pending.
That might happen. The likelihood of that
And
happening.
the client would grab you by the neck. I think that'll be okay. I did learn, because of another mistake, it makes me crazy. Tried very hard to be very careful. We filed for a legal separation for a woman a year ago. And she said, I want to amend and ask for a dissolution. So we filed an amended petition. Dave checked the wrong box and he asked for a legal separation a second time. Which of course was meaningless. So now I said, just file a second amended petition. Son of a bitch, you can't do that without court permission. So now we have filed a request for order for permission to file a second amended petition for a divorce, all of which will involve maybe $2,000 worth of time, and which obviously could never be billed to the client.
They can do your work.
So, you know, you have support staff, they need to be careful,
Absolutely.
and you need to look over their shoulder. I mean, that just shouldn't have happened.
No.
I am thrilled that the client is not terribly upset. She's not happy, but she's not terribly upset. The thing itself has been dragging along forever. So it's not like she's waiting to run out and get married.
I gotta go pick up my daughter. Please excuse me for today.
Good night. You're excused for today. I will see you.
Yeah, bring all the copies on Saturday for us.
That's great. Thank you very much.
I'll get the rest of the material from these guys later on. Whatever we discuss.
Thank you.
Good night, Darcy.
Thank you.
Tell your daughter, tell her to learn how to hitchhike.
You'll meet her at the graduation.
Oh,
Are you
great. I
gonna be
look
there?
forward to that.
Okay.
I look forward to that.
We'll see you guys.
Close to it.
You can set aside a judgment if it is a stipulated judgment, like a settlement agreement, if there is a mistake. If you say, if in the agreement you say wife gets to keep the house but owes husband $30,000, but the agreement had been she was to pay him 40, you can set that aside and correct that mistake.
It's a mutual mistake.
Yes. What you can't do is set aside anything or add something that you simply failed to address. You can correct something that's in there that's wrong.
So to that, if you
You can't fix it if it isn't in there at all. I gotta tell you, I mean, I just pretty well learned that today
makes sense.
in studying prior to my initial interview with this lady. Chapter 9. I have a guy who owes me about $3,000, and his wife died while the divorce was pending. And his position is, you didn't complete the case. I'm not paying you. Fuck him. Death terminates a marriage.
Fuck yeah. That just resonated.
Death terminates a marriage. The family court no longer has any jurisdiction to do anything. The probate court does.
Oh, God.
But the probate court is going to apply a bunch of probate rules and family law rules. Question. And to my embarrassment, I wasn't certain of the answer.
Risk of this phone, this guy. I want to start reading and buzzing this class.
A man dies, no will, wife and 2 children. Who gets what?
Man dies, no will.
He dies
Wife dies
intestate.
intestate with 1 wife and 2 children. So he already owns half of the community. So a man who dies intestate under the laws of wills and trusts in California gets the rest of the community property. So it's 100%.
She
What?
does.
Well, man dies. I'm sorry, she does.
She does.
So
She
she
can
owns.
give separate property to whoever he wants.
He can. Yes, the rules
But
are.
if he dies
Either of them
intestate, but he's
can't
died,
get their
he's
separate.
dead, he's died interstate. So the wife will get, depending on how many kids, if there are 2 kids, so the wife will get half
Half of the CP.
of the separate property.
Well,
She has all of her separate property.
75%,
She's going to keep her separate property.
right,
that wasn't the question. A man dies intestate.
interstate, so,
He has a wife and 2 children.
right,
What does she take?
right. If it's a separate property,
So the general rule is, if it's, let's say, on the community, of the community, she already owns half. So I think it's subject to discussion is his half of the community. And he died intestate,
Mhm.
she gets that half of the community.
The kids don't get anything?
No.
Are you sure?
Community property. On the community
half of
property.
whatever his,
Who gets his separate property?
so 75% his wife gets, 25% the kids get. Half of the community property.
She gets half of his community?
Yeah.
Is that how it works?
Huh?
My impression has been that the children share it.
He dies interstate. So is that's the traditional, what do you call that?
On death.
Tom Brokaw denies sexual misconduct
Oh,
claim.
no.
On
You're going
NBC.
after Tom Brokaw?
Do you have your Dachi book on you?
No, I don't. But I have,
Is everybody going to be accused?
oh my God, that's too much.
I'll pull my wills and
I
trusts.
have bar mats. What do you want me to look at?
Just look for death. Distribution upon death, intestate. Distribution of assets upon death. Yeah, distribution of assets, intestate. It's like
So you look at interstate, let's see.
intestate. Distribution of assets.
Look at trusts and wills. So trusts and
Boy,
wills.
that's a very good question.
Interstate. Any part of this estate not effectively disposed by will passes to interstate. Community property. Surviving spouse,
It's all,
100% of decedent's health share of community property.
yeah, it's all.
A surviving spouse inherits 100% of decedent's one half share of community property. The surviving
That's
spouse
right.
therefore ends up with 100%.
Because remember, the rule is, on
Same with the quasi-community, but separate
Yes.
property,
it's different.
surviving spouse or domestic partner, the fraction that goes to the surviving spouse or domestic partner ranges from 1/3 to all of the separate property, depending on how many and which other relatives have.
That's right, which issues are about.
So if there's no issue, parent, sibling, or issue of deceased
Right.
sibling, 100% goes to spouse.
Right. Because remember, when you talk about CP, you've got wife owns already that, husband owns that, so upon death, she gets this.
Yeah.
That's his half.
So if there's an issue, the issue would get half of the separate property.
Yeah, right. So if there's separate property, that's CP, and if there's separate property, and you have,
More than one issue, then 1/3.
it's divided for disturbance.
Right.
That's right. So the issue, let's say there's 3 issues. Let's go 1, 2, 3, and then wife.
Yeah.
So then it gets cut,
Yeah.
right? 50% goes to wife, and then this 50% is divided equally amongst the children
Yeah.
for disturbance.
Yeah, we gotta review that stuff, I forgot already.
That's a great question. It made me think.
Good. That's what I'm here for.
Yeah, longtime NBC newsman allegedly made sexual advances towards women in Kerr. Wow.
In car?
Matt Lauer is embarrassed and ashamed as wife moves forward with divorce.